silver linings are equally. I extend my heartfelt gratitude to Professor Nanjun Swami for giving me an opportunity to share a few words about public interest litigation. No matter, much has been discussed on public interest litigation all over the world. So why are you sitting here to understand public interest litigation? It's a fundamental question shall be asked whenever you want to go for understanding the subjective and objective approaches on public interest litigation. As you have already been known that we have had our own problems in the society, be it women, children, orphans, LGBT, refugees, internally displaced persons, and many. In fact, United Nations Organization and its half-century enactments are highly essential with a view to understand the crisis in the society. Let me share with you. There are as many as conflicting interests in the society. How do you overcome? Where exactly you can find some solutions? That's very important. Rather than just following problems for many years, you need to have some conflict resolution over here. Otherwise, it's very difficult. And moreover, if rather I would say, if you just look into the conflicting interest in the world, there are many conflicts between man and nature. To overcome a conflict between man and nature, solution can be found through science and technology. This is one thing. The second conflict is man with other men. Obviously, through politics you can overcome problems between man with other men. Last but not the least, you have a problem with yourself and others. How do you overcome? Through meditation, yoga, or on the basis of spiritual activities you can overcome. These are the major conflicting interests we have all over the world, be it in US, Europe, or Asia Afro-centric approaches as well. My observation is very simple when you are just sitting over here to understand public interest litigation. So where exactly you can file a case, how, in what manner public interest litigation should be called, what measures shall be called, which courts can hear the voice of the people. That's very important. It means that you have to give voice to the voiceless, eyes to the eyesless, remedies to the remediless. In the meantime, you have to understand what is all about triple justice. Triple justice in the sense that it could be political justice, economic justice, and social justice. So how would you understand justice over here? Why people are knocking the doors of judiciary? They need justice. That's very important. Who will go to court? Very few. Others, they have to close their doors, wipe out a little and say, this is my life, I should go. These are the major crises we have when you are just dealing with the society as a whole. This is one thing. On the other hand, before you are going to deal with public interest litigation, very little knowledge on the society is highly essential. Keeping enough the word hunger. So word hunger is ongoing all over the world, not only in India, cutting across the world. You can find starvation deaths, poverty, and moreover, if rather I would say, the conflicting interest among the nations are all actually remained even today, though you have had as many as international agencies and their half-century enactments. Looking into the perspectives on UN Charter 1945, wherein it starts with we the people of United Nations determined to save the succeeding generation from the scourge of war. That cannot be explained once again And moreover, it urges that there shall be international cooperation and mutual coexistence with a view to encourage and promote international human rights and many. So you have to understand even from the perspective of the human rights as well. And as you have already been known, violence, violence shall not be tolerated. Similarly, discriminations. Any discrimination or violence, you have to stand somewhere, fight for justice. That is our concern. Either it could be distributive justice or corrective of justice. There are two things you have to understand when you are just dealing with justice as well. On the other hand, if somebody is actually crying at home, mother should know why he or she is crying. That's very important. It means that a state should know if something has gone wrong to a citizen of this country or a national of this country as well. Any gross violation of fundamental rights or a directive principle of state policies, obviously you can move to the court, you can knock the doors of the judiciary for seeking justice. That's very important. Under Article 226 and 227 of the Constitution of India, we can move to high courts. Under 32, we can move to Supreme Court of India by filing public interest litigations. So what are public interest litigations? How exactly public interest litigations shall be called and looked into? And you know the fact that the moment when you're just dealing with public interest litigations, public interest litigation is a legal action initiated in a court of law for protection of a public interest. Then what is the purpose of a public interest litigation? Why are you filing certain cases before honorable courts? What made you to go there? Why you have gone there? What kind of violations you have? All these things shall be cleared at the moment when you're just moving to the court of law. This is one thing. On the other hand, access to justice is one among human rights. This is what we are Krishna in many cases before Supreme Court of India who could share on the basis of the concept of justice as well. Even in otherwise manner, Justice Anand of Supreme Court of India, former justice and chairperson of NHRC, National Human Rights Commission, who could share that poverty that itself is violation of human rights. So these are the major observations we have had when you are just dealing with the concept of public interest litigation as well. On the other hand, what are the aims of public interest litigation? Aims of public litigation is to facilitate common people to access the courts to seek redress in legal matters. It is a crucial tool for social change, accelerating the attainment of justice and law, upholding the rule of law. Here, I am just sharing with you what is rule of law. You don't require as many as the definitions to be given here. Rule of law means rule according to law. Nobody is actually above the law. Even king also under the law and God. I am not above the law. You are not above the law. Law is supreme. Constitution is supreme. You have to understand. First of all, you have to read and write Constitution of India. Then only you can understand what is all about the rule of law as well. You just go through Article 14, 15, 16, 17. That could be read out with Article 341, 42 of the Constitution of India, wherein they have outspoken on the people who have come from marginalized sections of the society or weaker sections of the society or the people who have come from retracted society as well. So keeping in view of all these examples, if rather I would say, why is people are knocking the doors of judiciary? They need justice. That's very important. Your access to justice is one among human rights. This is what many scholars who have already been outspoken. This is one thing. On the other hand, perhaps you may have gone through as many as illustrations. I'll give you an illustration through which you can understand what is all about a public interest litigation as well. One fine day, wolf was actually standing before a sheep demanding, a sheep, I want to kill you because I have a right to food. Then sheep replied politely, wolf, my friend, however you might have got right to food, you cannot kill me because I have a right to life. Perhaps the people who have come from a science background may have known on the basis of a fittest survives. So in this context, you have to understand the Charles Darwinian philosophy as well. So why I'm just sharing this illustration? Obviously, if rather I would say, the moment when you're just filing a case before the court of law, you have to understand what are the crisis between people themselves. Whether egg is first, a hen is first, seed is first, plant is first, military necessities first, humanity is first, men are first, women are first. We don't know, isn't it? Just because of few, what shall I say, sweeping statements or safe cornered statements, we are just safeguarding the interests of the people. That's a different issue. However, you should know what is all about justice before the court of law. Why people knock in the doors of judiciary? They need justice. That's why you are filing a series of cases before the court of law. I'll explain a few interesting cases filed before honorable high courts and Supreme Court as well. Under Article 226 and 227, you can move to high courts. Under 32, you can move to Supreme Court of India. If rather I would say Article 32, that itself is a fundamental right. Please remember, when you are just dealing with right to remedy, that itself is a fundamental right, without which other rights cannot be enjoyable. This is what many scholars who have outspoken, that Article 32, that itself is a heart of the Constitution. Please remember. So first of all, you have to touch upon what shall I say, the preamble itself. The very preamble of Indian Constitution, which could say that we the people of India, we the people of India. What does it mean? See, the moment when you are just defining Bharat or India, Bharat means people. You have to understand. Don't be defined on the basis of a geography as well. So anyway, the moment when you are just dealing with these, obviously, if rather I would say, Article 226 also empowers all high courts to issue writs for enforcement of fundamental rights. On the other hand, Article 32, Class 1 of the Constitution of India, which guarantees the right to move the Supreme Court by appropriate proceedings for the enforcement of fundamental rights conferred under Part 3 of the Constitution of India. Part 3 of Constitution of India has been in fact dealing with all these fundamental rights as well. This is very, very important from the point of view of understanding the fundamental rights as well. This is one thing. On the other hand, in a silver linings, class 2 of the same article, which is actually confers power on the Supreme Court of India to issue appropriate directions based on 5 writ petitions. You have 5 writ petitions like certiorari, quo warranto, habeas corpus, prohibition, mandamus. These are the 5 writ petitions can be filed before the court of law for understanding the subject matter of public interest litigation as well. So here you have to uphold public interest. This is very important rather than just sharing. On the other hand,
Sir, slides are not moving, sir.
Yeah. Is it okay?
Sir, visible, sir, but not moving, sir.
Now it's moving, no?
No, sir.
No, sir, not sir.
Yeah. Visible, sir. Now is it visible?
Sir, visible.
Yes, sir, but not moving.
Okay, 1 second.
1 second.
Now, dear participants, hello.
Yes, ma'am.
Yes, ma'am. Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Visible, sir.
Yes, sir, visible.
First of all, you have to question who can file a public interest litigation. Any individual or an organization can file a case on behalf of few people. Take for an example, all the time, few people may not be in a position to move to the court because of their poverty line or some, issues and challenges as well. So on behalf of few people, anybody can represent before the court of law. Perhaps we may have gone through as many as cases decided by Honorable Supreme Court of India. Take for an example, ABS case, Sangha versus Union of India. In this particular case, unrecognized association can also file a case before the court of law. This is what we are Krishna here who could acknowledge in many instances as well. Especially in judges transfers case, 7th bench of Supreme Court of India who could share that any member of public having sufficient interest can approach the court of law. This has been actually directed in this particular case. Any person who has got sufficient interest, it is not actually based on individual interest. There shall be larger interests of society. Any gross violation of human rights or fundamental rights, then anybody, I mean to say, any individual or organization can move to the court of law under Article 226 and 32 of the Constitution of India. Where can a PIL be filed? So can you file PIL before DC or Tahsildar? No, you cannot. PIL may be filed either before Honorable Supreme Court of India under Article 32 of the Constitution or any High Court under Article 226 of the Constitution of India. You have to understand the synergy or legal chemistry the moment when you are just dealing with the concept of public interest litigation. See, rather than just narrating on the basis of theoretical perceptions, I'll be sharing with you about the practicality of the public interest litigation. How exactly public interest litigation shall be called and looked into, where exactly you are going to file, who has to file, where exactly you can find the redressal of your grievances as well. Of course, no matter, people have come from little background. For them, law shall be made available. What is all about law? It is not actually something to be outspoken in otherwise manner. There is a closest connection between law and society. You have to understand. This is what one of the celebrated authors of America who could share that there shall be closest connection between law and society. You have to create a synergy between law and society as well. Take for an example, when we had a Nirbaya's case, what shall I say, gang rape case, who could share? Obviously, the society spread the message to all that there shall be justice to be given to a lady, especially country like India. This has happened. And even you can have a look on a Sabarimala's case and ADM Jabal Spur's case and several cases who could share on the basis of public interest litigation as well. So keeping in of this lies an instrument of social change. It may change from time to time as a science and technological development as well. This is very, very important from the point of view of understanding the problems available in the society as a whole. So that's why you have to understand from the perspective of the dharma. Dharma means righteousness. Judge what is right and what is wrong. You are a better judge. Judge what is right and what is wrong. What is good for me may not be right for you. That is there. However, there is a room for discussing all these issues rather than just quarreling each other. So, in the name of religion or caste or greed or local issues, You have been actually keep targeting people. That's not the right answer. If rather I would say you have to give justice to a common man. As I said, you have to give voice to the voiceless, eyes to the eyesless, or remedies to the remedyless. This is very important. You have to understand. So people should be lived in a peaceful manner. That's very important rather than just moving towards the wage war as well. This has happened especially in Pulwama and Palgam and the rest of them. This is not the right way to understand the terrorist activities as well. So keeping in of all these, moreover, if rather I would say any gross violation of human rights or fundamental rights or direct principles state policies, the people can represent on behalf of them. That's very important. And moreover, if rather I would say, it is all about kriya and karma. Kriya for yourself, karma for others. It means one owes duty towards others. One owes duties towards others in the sense that you have to help others. That's very important. You have to understand what is all about right, duties, and their liabilities as well. It means that where there is a right, there is a duty. Where there is a duty, there is a liability. This is one thing you have to understand. Even in otherwise manner, where there is a law, there is a remedy. Where there is a right, there is a remedy. So all these things shall also be actually called for. Suppose there is no remedies under the Constitution of India, what would be the consequences of citizens of this country or nationals or nationals of other countries as well? So keeping enough all these UGC remedium shall also be actually called for and looked into, where there is a right, there is a what shall I say, remedy as well. So that's why Article 32 that itself is called as the heart of the Constitution as well. This is one thing. On the other hand, looking into the perspectives on various judgments rendered by Honorable Supreme Court of India, in one of the interesting cases, I'm just citing over here, People Union for Democratic Rights versus Union of India. In this particular case, petitioner had a locus standi to file a petition for enforcement of various labor laws are concerned. See, any gross violation of rights of labor who are laborer, so who are actually working in a company, it means that you have to create a very good synergy between an employer and employee. They should go hand in hand. Keeping in of all these public interest litigations, you could find as many as interesting legislations who could pass for the survival of the people who have been actually keep working day and night in any industry as well. Take for an example, you have a Factories Act 1948, Industrial Dispute Act 1947, Workmen's Compensation Act 1923, then Gratuity Act, Bonus Act, then Equal Pay for Equal Work Act. All these legislations have been actually initiated on the basis of public interest litigations which were filed before honorable high courts and Supreme Courts as well. See, this is very important. You have to understand the moment when you're just dealing with problems between employer and employee as well. They should go hand in hand when you are just dealing with labor legislations as well. So apart from these issues and challenges, you just go through few interesting cases. Take for an example, Bandhu Mukti Morcha versus Union of India. Some bonded laborers had many crises. They were treated inhumanly and indifferently. So they couldn't find good conditions. Then a few people, they filed an application before Honorable Supreme Court of India for redressing the grievances of these bonded laborers as well. So they had some issues in stone quarries. So to overcome all these issues and challenges, Supreme Court came out with new approaches by saying that these the people who are actually working in stone quarries shall not be inhumanly treated. They should be given an opportunity to lead their lives. So that's very important. You have to understand their right to equality, then other rights which are guaranteed under Part 3 of the Constitution of India, which means that you have to uphold the constitutional values. That's very important. Yeah, keeping enough all these examples here and there. And moreover, I respect your truth. Please respect my truth. That is the strength we have. Even in otherwise manner, you should know where exactly you have come from. Then only you will be appreciated. Where are you going? In this way, you have to understand peaceful life. If at all you want to live with peaceful life, we need to have an active protection from the government or the state as well. State shall be a guardian of all these fundamental rights or human rights as well. State shall not be a violator of human rights or fundamental rights as well. So that's why state should protect the people. Yeah, that's why you are sitting here to understand the public interest litigation as well. See, public interest litigations can be filed by any person for a welfare of others who are disadvantaged and are thus unable to approach the courts themselves. Thus, the general rule of locus standi has been relaxed in cases of PL to protect and safeguard the interests and rights of these disadvantaged people. It means that few of them have come from a very little background, marginalized sections of the society, or weaker sections of the society, are retracted from the society. At least for them, law shall be made available to be helpful. This is very important. And courts have treated even a letter or a telegram as a PAL. And in case of rural litigation entitlement, Kendra, Dehradun versus state of Uttar Pradesh. In this particular case, mere letter is enough to find out certain solutions in connection to the subject matter of the gross violation of their human rights as well. Even the law regarding pending pleading has been relaxed by courts in case of public interest litigations as well. See, anybody who has had public interest can move to the court for redressing the grievances of these vulnerable groups as well. Take for an example, understand the problems in connection to women. See, gang rapes are also ongoing, marital rapes, digital rapes, all in all, they have been actually going on in the society. Look at and understand domestic violence are also going on. Who has to bell the cat? It's very difficult. I must share with you, who has to bell the cat? That itself is your sweeping statement or a safe corner statement. I must share with you, you have to bell the cat and watch where exactly a cat is actually moving. That's very important. You have to understand. Simply, you should not have had your own sweeping statements or safe corner statements when you are understanding the people who have come from a little background, especially women as well. She is highly vulnerable even today, as you have already been known. Why women are actually possessing more rights than men? My answer is very simple. It is because of historical injustice and practical denials. Women are possessing more rights than men as well in the society. You just go through Domestic Violence Act. They include even sexual harassment at working places, Act 2013 as well. Why these legislations have come? That's very important. You have to understand why domestic violence is actually going on. Then sexual harassment at working places are going on. So, keeping enough all these examples, you have to understand the problems of women in the society as a whole. That's one of the major observations we have. If something has gone wrong to these women, anybody, any organization can move to the court of law for redressing the grievance of these vulnerable groups as well. Take for an example, in Vishaka versus state of Rajasthan, perhaps many teachers may have known about this particular case, which was actually decided by Honorable Supreme Court of India in 1997 as well. isn't it? Vishaka versus State of Rajasthan's case. So based on Vishaka versus State of Rajasthan's case, 1997 case, you could find as many as guidelines which are given to all the public and private sector that could be given an opportunity to see the problems of women country like India as well. So keeping enough all these developments, petitions filed before Honorable Supreme Court of India in 2013. In fact, you could find um, a legislation on sexual harassment at working places 2013. It was possible because of a public interest litigations filed by many organizations and the individuals as well. So these are the major, what shall I say, examples I'm just citing over here to understand the public interest litigation. The courts have also highlighted the fact that Article 14 and 21 of the Constitution of India and international covenants on human rights provide for a fair and reasonable trial. Thus, courts must intervene when injustice is done to many. Simple answer can be given here. The moment when you're just dealing with this slide, obviously, you know, and it's a half century enactment shall also be actually called for to look into the matter in connection to the human rights as well. Just to see UDHR, Universal Declaration of Human Rights 1948, International Covenant on Civil and Political Rights 1966, International Covenant on Economic, Social and Cultural Rights 1966. All these covenants have been actually drafted at the international level with a view to understand or to safeguard the interest of men and women all over the world. You just see the article 1 of the UDHR, Universal Declaration of Human Rights 1948, wherein it talks about equality before law, equal protection of law as well. This is one thing you have to understand. The synergy between men and women. You cannot be a stronger by exploiting others. All are equally footing. This is what Article 14 of the Constitution of India is well noted. It means that like should be treated alike, unlike should not be treated like. Equality before law and equal protection of law, they should go hand in hand. That's why you have to understand Article 14 of the Constitution. That could be read out with 21 as well. Under Article 21, you are just dealing with right to life. It's a question of life. Please remember when you are just dealing with Article 21 of the Constitution of India. Article 21 of Constitution of India, that itself is called as a primordial right, without which other rights cannot be enjoyable. Right to life includes right to dignity, right to privacy, right to wholesome environment. Just look into some environment. Perhaps many scholars may have known how exactly human rights should be called through environment as well. What is all about right to wholesome environment? Perhaps you may have gone through as many as principles which are laid down. It could be polluter pays principle, sustainable development, intergenerational equity, precautionary principle, common heritage of mankind, common concern of humanity. All in all, you have had, no matter, but the problems are remained even today. A series of cases were filed even before Honorable Supreme Court of India with a view to understand the protection and preservation of human environment. Even at the international level, you could find as many as what shall I say, steps which were taken by UN and its half century enactments as well, be it Stockholm Conference 1972, Rio de Janeiro Declaration 1992, Earth Summits, Cancun, even under the umbrella of WTO. Series of steps were taken with a view to understand the protection and preservation of human environment as well. Apart from these, in 1992, in fact, I remember there were two main conventions concluded at the international level. International Convention on Protection of Biological Diversity 1992, and UNFCCC, United Nations Framework on Climate Change 1992. So these were the major conventions took place among the nations. So with a view to understand the human environment as well. So why these were actually possible? It was because of the world public opinion. You have to understand, world public opinion shall also be actually called for with a view to understand these the crisis among the nations as well. Looking into the perspectives on various problems, say for example, Yemen civil war, Syrian civil war, then issues in Ukraine, then Georgia, and rest of them, they're all actually ongoing even today, seriously speaking. So keeping of all these examples, who bells the cat, it's very difficult to be answerable. However, there is a room for discussing all these issues. You have to sit for a while and understand the people, how are they living. That's very important. Take for an example, refugees. Who are all refugees? Why refugee crises are actually ongoing? In India, we have Chakmas who have settled in Dharmasala, Tibetans who have settled in Bailkuppe in Karnataka. Okay, just to see the problems of Rohingyas or the people who have come from Nepal. They are all actually well settled country like India, not an issue. However, you should see the problems of what shall I say, refugees. Who is a refugee? It's a fundamental question shall be asked. Refugee is a person who has been fled his home country due to well-founded fear and persecution. This definition is actually outdated definition, as I believe. So critically speaking, see, even for some reasons, take for an example, economic migration is one of the major root causes of refugee crisis as well. You have to understand how, in what manner, economic migrations are also being actually called one of the major crises of what shall I say, refugee issues and challenges as well. So therefore, you have to represent on behalf of these uh, refugees and internally displaced persons as well. Take for an example, I'll give you some instances in connection to the subject matter of IDP, internally displaced persons. In India, we have more than 7 lakh internally displaced persons, especially in Jammu and Kashmir. You can find 2 lakh 80,000 Pandits who were actually migrated from Kashmir Valley, settled in Jammu as well. Even today, they are not at all finding, very good positions as well. You just represent on behalf of these IDP as well. This is one thing. You just looking into, you just go through the position in Karnataka. Say, for example, perhaps you may have visited BRLs, Nagaravale, Bandipura, and Ankola, Jaida and all. You may be witnessing series of issues and challenges being faced by internally displaced persons are concerned. My question is very simple. Who are these people? Have they come from America? Have they come from European countries? Have they come from African? They're from your own country. Please remember, when you are just dealing with internally displaced persons are concerned, they are highly vulnerable even today. They are not at all finding place to live. They are in marginalized level. So at least for them, laws shall be made available. We talk many things on the basis of Constitution of India and international covenants. That's there, not an issue. Look into these issues and crises, you will be known how exactly these people are vulnerable even today. This is one thing we have to understand. Of course, no matter, series of cases have been decided by Honorable Supreme Court of India. No matter, I'll just refer some interesting cases. Take for an example, MC Mehta versus Union of India, Gaurav Jain versus Union of India, Manna versus state of Uttar Pradesh, Lakshmikant Pandey versus Union of India, Vishaka versus State of Rajasthan, Ramesh versus Union of India, then Rudul Shah versus State of Bihar, Bhim Singh versus State of Jammu and Kashmir. All these cases were in fact decided by Honorable Supreme Court of India with a view to understand the public interest litigation as well. So my observation is very simple. Anybody can represent on behalf of these vulnerable groups as well. See, you're all well off, that's a different issue. Some people have come from little background. Say, for example, SCs, STs, minorities, women, orphans, for example, LGBT sex, internally displaced persons. Look at and understand child labor. It's ongoing even today. Nobody knows how, in what manner these people should be rehabilitated. That's very important. You have to understand from the perspective of the system as well. In any society, it could be in the form of a Euro, US, or Asia Afro centric approach. You may be finding a lot of crisis among the nations as well. This is one thing. Let me share with you, as you've already been known, if you are close to high temperature, the high fertility will come. When you got high fertility, population will be increased. When you got population, problems are many. So you have to understand this synergy over here. Otherwise, it's very difficult to understand what is all about the public interest litigations as well. What is the procedure for filing a PIL? So I'll just go through practicality of the public interest litigations as well. First of all, the moment when you're just filing PIL, public interest litigation, identify the issue. So what kind of issues we have? You have to find out. First of all, you have to research and gather some information. Without grounds, we cannot move. Judge will ask why you have come to the court, where exactly public interest is actually being squeezed. All these questions can be clarified before the court of law. Otherwise, it's very difficult to move to the court. So in this way, you should have a lot of grounds to file PIL before honorable high courts and the Supreme Court as well. You have to go through research. Either it could be on the basis of doctrinal research or non-doctrinal research, qualitative, quantitative research, deductive or inductive research, hill climbing research or waterfall research, or else on the basis of socio-legal research. You can gather some information through reflective thinking or traits and abilities, or in otherwise manner based on your observation. You can gather some information. Otherwise, it's very difficult to file a PIL before the court of law. What I would like to share with you that the moment when you're just filing PIL, public interest litigation, before these courts, you should have had more information. That's very important. The consult a lawyer. So you have to talk to your lawyer and get back all information. That's very important. Then you can go for drafting of a PIL petition. So all grounds shall be made available compulsorily. Then affidavit supporting documents should be enclosed when you are just filing PIL as well. Then you can file a petition, serve a notice, court hearings might be there. Then last but not the least, you can have a justice before the court of law. All decisions can be made available on the basis of these procedural matters as well. Here, procedural law, whatever you are going to say would be incomplete. This has happened in many cases, as I have already been noted. Similarly, especially in Bandhu Mukti Morcha versus Union of India, then Workman's Rubber Company of India versus Management, then People's Union for Democratic Rights versus Union of India, then Syndicate Bank and others versus Umesh Nayak, MC Mehta versus State of Tamil Nadu. So all these cases were in fact decided on the basis of certain issues and the challenges as well. You have to have as many as grounds to file PIL before honorable courts are concerned. Otherwise, it's very difficult to understand the public interest litigation as well. See, details to be cleared for drafting a case. Then what kind of details should be given in a draft? That's very important. The petitioner's name, postal address, email address, phone number, occupation, annual income, and PAN number should be given. Then proof of identity of petitioner must be annexed. Facts of the case. So that's very important. You have to understand the facts of the cases. That's one of the major aspects that shall be clear. The nature of injury, what kind of insult you have, violation you have. All these measures should be, what shall I say, cleared the moment when you're just filing PIL before the court of law. As I said, and on the basis of a few examples like women, children, orphans, then LGBT sex, and all these people might be there. They do have their own issues and challenge. Just represent on behalf of these people on the basis of these grounds as well. Then any personal interest that he or she may have, that should also be actually looked into. So I am just sharing. See, when you are just filing before honorable court, the judge will ask why you have come to the court, where exactly your public interest is actually being violated, either an individual interest. All these things should be clear before just moving to the further proceedings as well. So before you are going to deal with all these proceedings, first of all, judge will ask these clarifications. Without understanding the public interest litigation or locus standi or social interest litigation, you have no moral right to move to the court with a blank paper as well. That's very important. You have to understand. And on the other hand, the class of persons for whose benefit the PIL is being filed, how they are incapable of accessing the courts themselves. Sometimes, people may not be finding economic venture to file their cases as well. Sometimes they may not be in a position to find out a support from anybody. So in such a situation, any organization or an individual can move to the court of law. This is very important. I'll give you some examples. In Prakash Cotton Mills versus state of Maharashtra. In fact, this case was actually moved to the Bombay High Court with a view to understand mass atrocities, especially in Maharashtra as well. So in this case, in fact, Justice Chagla, one of the best followers of Dr. B.R. Ambedkar, who could share that on the basis of the concept of social justice. See, without understanding social justice, law cannot be interpreted. Similarly, V.R. Krishnayar, Justice Bhagavati, then Hidayat, H.R. Khanna, as many as judges who could write their judgment favoring the vulnerable groups who could share on the basis of the concept of social justice as well. This is one thing I would like to share before you all. Even in otherwise manner, few interesting cases were filed before Honorable Supreme Court. Take for an example, Prithviraj Chauhan versus Union of India. In this particular case, Prithviraj Chauhan, who could argue on behalf of SCs and STs, country like India, the facts based on mass atrocities, especially in India. He could share on the basis of Section 18A of the Atrocities Act 1989 as well. This was actually upheld by Honorable Supreme Court of India based on Prithvi Raj Chauhan's approaches before Honorable Supreme Court of India as well. This is one of the interesting cases you have to understand the moment when you're just dealing with um, Atrocities Act 1989 as well. This was possible on the basis of Prithvi Raj Chauhan, an individual who was actually serving as if an advocate before Honorable Supreme Court, who could move, who could represent on behalf of scheduled caste and scheduled tribes country like India. This is one of the interesting cases. Please note down the moment when you're just dealing with Section 18A of the Atrocities Act 1989 as well. So this is one of the interesting cases. Never ever be forgotten the moment when you're just dealing with the public interest litigation as well. On the other hand, when you are filing public interest litigation, you have to understand the procedure. There is no second thought in it. Your proof of identity of petitioner must be annexed. Facts of the case, nature of the injury, physical or mental, all these things should be clear before filing a case. This is one thing. Any personal interest that should also be actually looked into. Details of any litigation involving petition which could have a legal nexus with the issue involved in public interest litigation. On what basis you have come to the court should be cleared. Simply you cannot file PIL based on your individual interest. Any individual interest cannot be withstanding before the court of law. You say, immediately judge will reject your application if something has gone wrong. This is one thing you have to be cleared. In the event that any representation have been made to any authorities regarding the issue, the details of the same shall be made it clear. All these information should be given to the court in a good manner. That's very important. Then any person, body, institution that may be affected by PL must be joined as party. Then petition must also state and they are able to pay cost, if any, that may be imposed by the cost as well. So that's there. This is all about procedural matter. I'm just showing here. You have to understand how, in what manner PL can be filed, what procedure shall be made, and how exactly preliminary proceeding shall be proceeded when you have filed an application before honorable high courts and the Supreme Court as well. This is very important. You have to understand. See here, I must share with you. There shall be gross violation of your public interest. It is not actually based on individual interest. Please remember. And moreover, if rather I would say, the moment when just filing PIL, there shall be locus standi. Locus standi, this is one thing. On the other hand, there shall be social interest. You have to understand the socially. This is very important because you are not living alone. You are living with many. You are living with your wife. You are living with your husband. You are living with your parents, you are living with your publics, and all in all, you should know you are not at all living alone. You should know what is peace in the society. Peace, it does not mean it is an absence of war. Peace means presence of justice. That is very important. You have to understand triple justice: social, economic, and political justice should be shared to the people who are left out in the society. That's very important from the point of view of understanding the concept of the justice as well. See, on the other hand, if rather I would say, of course, there are many things have been actually looked into to understand these writ petitions before the code of law, be it certiorari, coerento, prohibition, mandamus, habeas corpus. These are the 5 writ petitions are there to understand PIL as well. There is no second thought in it. But you should know how, in what manner states arbitrary action should be looked into. Any gross violation has been taken by the government officials or the government, or something has gone wrong to the group of people or few public, in such a situation, any organization or individual can file public interest before the court of law. See, as long as you are dealing with these, so long you shall not be forgotten on important features of public interest litigation country like India. See, as I said, anyone can file a PAL. This is one thing. The wide ambit of issues shall be made available, and a quick resolution shall be made, remedies to be granted, preventive and proactive measures shall also be actually looked into. These are the major important features we have when you are just dealing with the subject matter of what shall I say, public interest litigation as well. See, as long as you are just dealing with the concept of right to life, you shall not be forgotten on right to privacy, right to travel abroad, right to live with human dignity, livelihood, right to shelter, then right to health, medical assurance, nutritious food, right to diet. That is there, but it is actually restricted. It means that all rights are not absolute, as you have already been known, subject to certain limitations. This is what many scholars who have been outspoken, perhaps the people who have come from a political science background may have known the efforts made by Rousseau, John Locke, and Thomas Hobbes, who have outspoken on the subjective approaches as well, based on their social contract theory as well. Keeping in view of all these examples, Rousseau once said, "Man is by born free, but everywhere he is in chain." This is one thing. On the other hand, Thomas Hobbes also shared his views on the basis of the uh, problems in the society as a whole. Take for an example what he said. He said that man was actually highly brutal. Force is ultima ratio. So, in order to regulate him, law shall be made available. Through law, we can overcome. That's very important. So without understanding law, it's very difficult to understand the synergy between the law and society as well. You have to understand chemistry between what shall I say, the law and society. Law and society, they should go hand in hand. Any contradictory or contrary issues and challenges between these two would be major crisis as well, and you have to face a lot of issues and challenges. This is one thing. On the other hand, when you are dealing with the right to life, so right to life, it includes right to education, free legal aid, right against solitary confinement, right against handcuffing, speedy trial, fair trial. It means that free trial, whoever may be committed wrong in the society, that's a different issue, isn't it? Even today, murders are also taking place, rapes are also taking place, ongoing issues and challenges we have had, no matter. But the moment when you're just prosecuting them, we should follow substantive and procedural matters as well. This is what law says. And moreover, just go through the part third and part fourth of the Constitution of India, wherein you have outspoken on the basis for these factors as well. So, then matters entertained by PAL. So these are the issues we have. Take for example, bonded labor matters, neglected children, no payment of wage, minimum wage to workers, exploitation of casual workers, atrocities on women, environmental pollution, disturbances of ecological balance, food adulteration, maintenance of heritage or culture. So on behalf of these issues, you can file PAL before the court of law under Article 226 and 32 of the Constitution of India. It means that you have to uphold the constitutional goals as well. This is very important. See, you know very well, better than me, in the name of caste, creed, color, religion, you have been keep targeting people. In the name of good things, we have killed many. This is very serious issue. If rather, I would say, on the basis of public interest litigation as well. In India, even your food has become a religious issue. This is very sad story. I'm just sharing over here on the basis of the Constitution of India as such. You just go through the preamble itself. What else you want? See, which constitution you want? Country like India. Would you like to have Yagnavalka Smriti, Manusmriti, Narada Smriti, Kautilya Saptashastra, Agni Purana, Mahabharata, Ramayana? You are not actually cleared here to understand your own constitution. First of all, you have to read the constitution. So far, you have not been actually read out Constitution of India thoroughly. I think this is the right time to read and write Constitution of India thoroughly. Then only you can understand others, isn't it? So whenever you want to go for understanding your life, please understand others. That's very important. That's a karma you have. See, obligations towards others. You have to have. Otherwise, it's very difficult to understand a synergy between rights and duties as well. As I said, where there is a right, there is a duty. Where there is a duty, there is a liability. These are the what shall I say, equations or formula we have within the limits of our own jurisprudential understandings as well. So therefore, you have to sit for a while, understand these crises as well. Otherwise, it's very difficult to have a look on the public interest litigation as well. Moreover, as you already been known, that PIL is a legal mechanism that allows individuals or groups to initiate legal actions in court to protect public interest and enforce legal rights, even if they are not directly affected by the matter. It's essentially a tool for addressing issues of a broad public concern, often related to human rights, environmental protection, or government accountability. It means that, as you already been known, a state should be a protector of human rights and the fundamental rights as well. Any gross violation of these rights, which are guaranteed under Part 3rd and Part 4th of the Constitution, then he can move to the court for redressing the grievance or compensation as well. This is very important. And moreover, if rather I would say, PIL is a form of judicial activism where courts take proactive measures to address issues of the public concern as well. This is one thing. PIL makes justice more accessible to marginalized and vulnerable groups who may not have the means to sue on their own. Sometimes they may not be in a position to file a case directly. On behalf of these, anybody can represent. That's a dharma or karma you have in the society. Dharma in the sense that righteousness, as you have already been known. One owes duties towards others. That's there. Then PL cases have been filed on the issues like pollution, bonded labor, neglected children, or environmental damages. So as I have already been stated, on the basis of a few interesting principles of the environmental law, perhaps many scholars may have known how, in what manner, basic principles of the environmental law should be called and looked into. This is one thing. Any gross violation of these, anybody can move to the court of law. This is one thing. Just giving you some citations, please have a look on. Hasinara Cotton versus State of Bihar. In this case, on the first reported instance of PAL in India, which brought attention to the issue of inhuman conditions of prisoners and under trial prisoners as well. Perhaps people may have committed wrong. That's a different issue. Very well, better than. So as long as they are living in prisons, their rights should have been actually well protected. Though they are not absolute. They are all actually restricted, I know. As long as you are lawful and subjective, obviously, the rights which are guaranteed under the Part 3rd and Part 4th of the Constitution should be absolute. This is my understandings about the rights which are guaranteed to the citizen of this country and the nationals of this country as well. So this is very important. See, when you are dealing with the Constitution, you see, some say that on the basis of preamble, it has got 25 parts, schedules. There are some articles. Powers and functions have been actually given to state and center. There are some powers have been actually given to governor and the president of India, prime minister, chief minister, cabinet. All these things we have based on legislature, executives, and judiciary as well. I agree with you, no matter. That's not the way of reading and writing the Constitution of India. You just go through Constitution of India in a deeper and deeper manner. Then only you can understand how in what manner Constitution of India was actually drafted by the drafting committee as well. This is very important. You have to understand when the moment when you're just moving to the court of law. Without understanding Constitution of India and human rights as well, it's very difficult to file PAL before court of law, public interest litigations as well. See, looking into the perspectives on Vishaka versus State of Rajasthan's case, in this case related to issue of sexual harassment, as you have already been known in the working places as well. As a result, Vishaka guidelines came into effect, published in 1997, which provided employers with the definition of sexual harassment, the list of preventive stages, then information on filing complaints of workplace sexual harassments as well. You have to understand, you have to give very good, peaceful to the people who have come from the marginalized sections of the society. That's why I said, why laws are favoring women? Because of historical injustice and practical denials. People, especially the women are possessing more rights than men as well. This is one thing. On the other hand, just see MC Mehta versus Union of India. So in this case is actually related to pollution in Ganges basin. This case was actually well noted for the protection of a human environment as well. You have to understand your surrounding circumstances. That is a concern. See, as long as you are just dealing with environment, you shall, so long as you shall not be forgotten on your ecology. What is ecology? Perhaps a few the people who have come from science background may have been known about ecology. Ecology is actually surrounding circumstances of organisms and their environment. It could be plant ecology, animal ecology, freshwater ecology, marine ecology. So all these things should be looked into. Any thing happens, obviously, in such a situation, anybody can represent for the protection of human environment as well. That's a concern should be shown. This is one thing. On the other hand, you just have a look on Paramananda Katara versus Union of India. In this particular case, this case was filed to facilitate hospitals to handle emergency accident cases without concern for pending police investigation. The judgment made it obligatory for a hospital or a doctor or public or private to provide immediate medical aid to road accident victims. This was actually possible because of this particular case as well. So anybody can represent on behalf of these people as well. This is one thing. Have a look on Javed versus State of Haryana in this particular case also. The constitutional nullity of then population control provision governing the panchayat election was actually challenged before Honorable Supreme Court of India as well. See, this is one thing. I'm with you. India is actually known for its international relations. That's why we could sign as many as international covenants. Please remember. And moreover, if rather I would say, India is one of the member countries of United Nations and its half century enactments. So keeping in view of all these examples, you have to borrow such kind of international law into the municipal as well, have very good synergy between municipal law and the international law as well. I must share with you, they should go hand in hand. So why people are knocking the doors of judiciary? They are not come here which law is supreme, whether municipal law is supreme or international law is supreme. None of their business. So this is one thing you have to be looked into. And moreover, as you already been known, especially in 1988, we had a Bangalore Declaration. This declaration was highly essential with understand the transformation of international human rights law into the municipal law. It was possible with a view to understand the problems of vulnerable groups at the local level. This is one thing. On the other hand, in 1986, 86, based on UN mandates, you could find a declaration on right to development. It was possible on the basis of crisis between haves and have-nots, or rich and poor, or developed and developing countries as well. You know better than me that if you have got money, you are going to exploit somebody. If you don't have any money, you will be exploited by somebody else. That would be an order of the day. You cannot stop poverty or something else. You can have some, what shall I say, schemes to overcome poverty as well. This could happen when this declaration came in at the international level. Later on, after 1986, we took almost 15 years to have some, what shall I say, new millennium goals in 2000. Later on, in 2015, you could find sustainable development goals. Perhaps many scholars may have known what are sustainable development goals. That's there. We have had our own action plan at the international level, like 2015 to 30. Let's see how, in what manner these sustainable development goals are highly helpful to the people who have been actually living in a country like India. That's very important. You have to see all these measures. Otherwise, it's very difficult to understand the gross violation of human rights or fundamental rights of these vulnerable groups as well. This is one thing I must share with you. Of course, there are some challenges in connection to the subject matter of PIL. Sometimes people may misuse PIL, public interest litigation. See, first of all, you have to understand the objectives of PIL, public interest litigation. So once you have gone through the objectives of basic principles of PIL, you are liberal. Otherwise, you may be misusing the public interest litigation as well. This is one thing. Lack of access to justice. Sometimes you may not be in a position to reach out justice. That's also one of the major challenges we have when you are listening to understand public interest litigation as well. Then overburdening of judiciary. A lot of cases are filed before court of law. Sometimes judges may not be in a position to find out a time to hear you before the court of law. Sometimes they may take a certain time to hear you. All these issues and challenges we have when you are just filing a PAL as well. Then limited effectiveness. Sometimes it may not be effective. It depends on the larger interests of the society as well. So keeping in view of all these measures, obviously, if rather I would say based on the constitutional measures, we have, of course, review petitions, revision petitions. Once you have failed in a revision or review petition, you can move to curative petition. See, how, in what manner curative petition should be called? Any gross violation of the rights of the larger interest. That's the ultimate. Since 2014, we have been actually keep filing some curative petitions before Honorable Supreme Court of India as well. So by and large, if rather you would say, of course, you have to understand subjective and objective approaches of PAL first of all. Once you have gone through subjective and objective approach of PAL, nothing will happen. Sometimes for mere reasons, with a view to understand their individual interest, some people may be instigated to file PAL before the court of law. That's one of the major issues and challenges we have, country like India. I must share with you, please use PIL for good causes. That's very important. Don't misuse public interest litigation as well. Of course, you shall not be forgotten to understand criticisms of public interest litigation. Despite giving several important judgments, PL still have few flaws you have to understand. PL has become a tool for harassment as a result of large number of insufficient cases that are filed by people with a minimal court fee as well. This is one thing. On the other hand, numerous false cases are also filed. Even some intellectual criticize the judiciary for overreaching through the public interest litigation. It means that your what shall I say, judicial activism should have had its own limitation. Don't be overreaching. You should not bypass the Constitution of India. That's very important. Whenever you want to go for filing bail before the court of law, it should be read out on the basis of constitutional checks and balances. See the part 3rd and part 4th of the Constitution, verify and understand, then you can move to PAL. Without understanding all these things, whatever you are going to say would be say on PAL would be incomplete. This is what I wanted to share with you. No matter, at the end, I can say that, see, law is there to protect and promote human rights and fundamental freedoms of these citizens of this country. In this way, we have to uphold the constitutional checks and balances. Constitution is supreme. Constitution that itself is a suprema lex, and it is a lex specialis. Please remember, with a view to pass this Constitution of India, we took almost a million years. So this is very important. At the end, I can share with you. First of all, you have to read the Constitution thoroughly. Then only you can be appreciated others. See, this is one thing. As long as you are living on this earth planet, so long you shall not be forgotten on the rights of others. That's very important. With you to understand the right to life, which is well noted under Article 21 of the Constitution of India. So thank you very much for giving me an opportunity